Kellen Voyer. He is going to be talking all about agreements, contracts, publishers, all this kind of stuff. Kellen, introduce yourself. How can we learn more about you?
Well, my name's Kellen. As you know, I'm a video game lawyer based out of Canada with a focus on publishing agreements. But we work with clients across the US, Canada, Europe. I'm in London right now. This is not Canada. And you can get a hold of me, Voyer Law, VOYERLAW.com. I'm glad to answer any questions after this that anyone has if you want to send me an email.
Yes. And that's great because we will be doing Q&A. We're going to go about 30 minutes and then we can go over there. I was going to say, I thought that was Montreal. I was like, boy, it really does look like Europe over there. Okay. Well, thank you. Beaming in remote from London. Way to go. Okay. So first, you're a lawyer. Do you want to do that standard lawyer thing about advice and all that kind of stuff?
I'm a lawyer. It's free advice. Don't rely on it. Get your own lawyer. I'm not liable for it. There we go.
Got it. Okay. So I'm going to ask you all about publisher agreements, but here's the thing is, when we hire the lawyer, when should we do this? So let's say I'm negotiating with like 3 or 4 publishers that some have served interest. Sometimes they email me and say, hey, we'd like to publish your game. And we start getting closer to negotiations. What is I know it could be, depends on a lot of things, but when should be calling the lawyer? In other words, should I start kind of redlining some of these things that you tell us in this talk and do it on my own? And then towards the end say, hey, can you get a final glance at this? Or should we be hiring you like the moment we think we're going to get a publisher?
I think you should be hiring a lawyer, whether it's me or someone else, before you're even at that publisher stage, to be honest. You should be doing it when you're forming your studio on whatever day that is. Because the common problem you're going to encounter at the publishing agreement stage is that if you did the incorporation yourself or you didn't do it, there's a big risk that the company itself, whenever it is formed, doesn't actually own the game. There's this assumption that if you create a company yourself and you're the sole owner of it, that somehow magically the company's going to own the game. That's not actually the case. So a common problem you'll see, and it comes up at the publishing agreement stage, because the publishing agreement says, developer, please guarantee to the publisher, which is called a representation and a warranty, that the developer's studio owns the game. But if the lawyers actually looked at the company, if it even existed, usually all that paperwork's missing because it actually needs to be separately produced and it's not part of the incorporation process. And this can be compounded because you could have had a bunch of third-party developers on the team, or maybe you had people come and leave the team. You need to go back to these people and say, we have a publisher now. You did the textures. You did a bit of an NPC mechanic. We need you to go and assign that to the company because we need the company to own it under the publishing agreement. So I think lawyers should be involved in a much earlier stage, so then you don't have to pay more to go back and try to fix all these game ownership problems, which are probably the most prevalent issue we fix on a day-to-day basis for our video game clients. But on the publishing agreement side, assuming all that is done, then I think when you're at the term sheet stage, if the publisher is providing a term sheet, is probably when you want to involve legal. If you're looking for legal to give you advice more so on the business terms and some of the legal in the term sheet, but a lot of the term sheet will be business-based. And so for video game lawyers, they're used to seeing a lot of publishing agreements, or you hope they would. And so we can provide that value and say, well, this advanced term or this royalty clause, there's some disconnect from what the market actually is right now, terms-wise. And it's better to provide that advice and to get that advice at the term sheet stage rather than you're already at the agreement and you need to come back and say, actually, I talked to a lawyer and he says these terms that I already said I was comfortable with on the term sheet need to be changed again. And that's never good optically. You may not always get a term sheet, depends on the publisher. But if that's the route that's happening, then I'd say get a lawyer at that stage.
Great. And do we say that we have a lawyer? In other words, like if you're talking to the publisher, like, oh, I'd just like to throw this over to my lawyer, or do you kind of keep it simple, try and kind of just say like, hey, I'm just a simple indie, and then kind of like on the sly send it to your lawyer? When do we drop the lawyer bomb on the publisher?
I don't know when my clients drop it because I never get it direct. I always get it like through the client, and then the client takes and sends it back to the publisher. Because usually when lawyers are involved in other transactions, we're directly corresponding with the publisher's lawyer. But publishers very rarely have their own lawyer. And they might have in-house, but I swear most publisher deals, I don't see comments back from other lawyers. So usually it's biz dev people that are looking at it. And I think that creates a softer tone where it's the dev sending the comments back. But the publishers don't really mind that you have a lawyer. So you can tell them at whatever stage. I don't think it creates some sort of adversarial vibe or anything like that. I think if it does, the problem's with the publisher, because obviously you want to protect yourself best. A publisher at some point engaged a lawyer to draft the document. So they protected themselves at that point in time. Why can't you do the same? So I've never had much of a concern with the dev having a lawyer in the first place. So I don't see any risk with introducing it later or just keeping it on the DL if you want. But at some point, they're going to figure out, given the nature of what comes back from the lawyer, that there's somebody with some degree of sophistication on the other side of the background.
I'm just a simple indie just thinking that this clause is totally out of line.
Yeah, here's this complex technical markup.
I don't know. I think I would just keep it on down. But no, I'm just kidding. Okay, so we're going to go through some of these top 5. What do you see? What are the 5 main clauses that kind of like raise the hairs on the back of your neck? What should we pay attention to when we get these kind of either term sheets or the contract back from the publisher that we're looking at?
For sure. I think where you would start is probably the advance, which is the amount of money you get from a publisher. Obviously, the money matters the most. It helps you fund the game development. So you're going to start with that every single time. We can get into kind of the details on what a regular advance looks like and things like that. Next, you're going to be focusing on the royalty clause, as in the amount of money you actually make back from game sales. And there's a lot of nuance there in how that royalty is calculated, and especially as how it connects to the advance. You're probably also going to be looking at the marketing clause as well. You work so hard on the game, and now you're at a point where it's going to be pushed out to the public. So the tone of that marketing, but also importantly, how much money is being allocated by the publisher to the marketing of the game, because that's going to determine success for a lot of titles, is super critical. Another one would be intellectual property. So that would be ownership of the game. We think that's always really important to address, obviously. And we'd also look at kind of continued obligations to support the game, whether that's DLC and things like that. But it could also be even like support, technical support and things like that, and how that tracks over the term of the agreement. And to add another one on there too, always look at the term, the duration of the agreement. You don't want it to be forever, which would be perpetual. And so we would look at that as well. But every clause has its own value. But those are the ones I would usually look at to correct a lot of the main ones, main issues I see.
Gotcha. Now, publishers, do we have an adversarial relationship with them, or are you looking at this stuff like, hey, we're all on this, we're all just trying to do our best jobs here? What's kind of your thought when you see some of these terms?
Yeah, I mean, my view is we're all on the same team. We want to get the game out there, but it's adversarial to the extent that the publisher wants to get the most publisher-friendly terms. So there has to be a degree of pushback. We speak to some people. I spoke to someone last week, and they were really trusting in the publisher statements, and the publisher wasn't willing to commit much to writing. And that's fine, where you expect that nothing will ever go wrong, but there always are those cases where things go wrong. So putting trust in the relationship isn't always great, but that goes to that point of it is inherently adversarial to some degree, in that if you don't protect yourself, then when things do go wrong, you're not going to have those protections that you negotiated for. And I think any publisher would expect you to push back. They might say, this is our standard terms, get lost. But at least you should try to do that rather than negotiate against yourself and assume that you can't push in certain areas. And if you work with a video game lawyer, a lot of them will say, for so-and-so publisher, like Team 17 or somebody, we've done enough deals with them to know that historically they've never made these changes. So if we're going to focus on clauses that add value, then we're going to instead push in different spots where we know they do give. And so I think that's something that can make things less adversarial as well, because we know what offends the publisher and what doesn't based on recent deals with them. And then also we know what they'll give us any day of the week because they've given it to other clients, and we can plug that in and save you money because we know exactly what they'll take.
Gotcha. So then when we look at these 5 main areas that you outlined here, what's the one that the publisher really cares about is like they focus all their attention on, and which are the ones that are kind of like boilerplate? Maybe it was like a template a long time ago. They just kind of pulled out. Where do you focus most of the negotiation on most of the time?
I'd say we probably focus most of the time on the business terms surrounding revenue share and surrounding advance. Those are probably the two biggest points. And with a publisher, money matters most. So those are the two money-driven terms. Other things secondary to that, you might be marketing commits as well. Publishers love to talk about the amount of money that they could spend on a game. But once you actually say, that's great, you've mentioned $100,000 10 times, let's put that in the agreement, they say, whoa, we're not willing to do that. That's crazy now. And so, that's another area where I see often pushback in trying to get them to commit to the things that they say verbally in writing, because why would they say it verbally if they weren't going to honor it?
Great. So let's talk about that. Let's talk about the revenue share and the advance. What are the things that you see most commonly that are kind of problematic in these contracts? For
sure. So I guess in the advance itself, the obvious one is what that amount of money is, but also how it's paid out. So it's often going to be paid out in stages or in tranches based upon the publisher's acceptance of milestones. So you're going to be looking at how those milestones can be accepted, because obviously if they reject a milestone, you're not getting that payment. So I think on the advance side, that's really critical. But you're also looking at the advance and how long it pays out relative to the contract term. And that does connect to the rev share. So a common problem is that you won't receive any revenue until the publisher recoups the advance amount. So if you have a $500,000 advance and you're not getting any money until that advance is fully recouped, there are scenarios where you may never receive a dollar, or it might take a year or something for you to receive a dollar. And then you take that to an obligation to make DLC or to provide continuing support to make sure the game continues to operate, or community management and all of that. Well, if you have no money coming in at all for a year in that scenario, how can you pay for any of these things? You'll have to let your whole team go. So what we're often looking at, going back to the advance, is to make sure that where you have a royalty that's not going to be paid out immediately because of how the advance is recouped, to make sure that you do have advance funds coming in even after the game's released, so you can ensure that you have that money to pay your team and to continue performing your contractual obligations in the first place. You don't want to not be able to provide support anymore, and the publisher goes and says, well, you breached the agreement because you're not providing support. Like, well, you didn't give us any money to provide support separately, and we're not getting any money under the actual agreement because of the advance not being recouped. So we definitely want to avoid that scenario. So to me, that's mission critical.
A real quick question there. This is where, okay, so I do marketing. That's my side of the thing. And, Steam, I focus on Steam. It's optimized. Their algorithms optimized to these kind of living games that are constantly updated. You get so much visibility when you update your game. You put out news and DLC, all these things that are lifetime of the game. Why, from their business interest, from a purely like capitalist business interest, it makes sense not to do those 100% recoups, because you want to feed this team that is going to update this game that they put a lot of resources in. Why do publishers do these 100% recoups? Are they just jerks, or are they naive? Do they not know this is how Steam works? Like, why 100% recoup? It just makes no sense to me.
Yeah, it puts a lot of pressure on the developer. And sure, if it's $150,000 advance and it's mostly marketing spend, you're fine. But other than that, I see that in a lot of large deals, and the larger the deal, the bigger the issue is. I don't know. They're trying to de-risk things for themselves, but I guess they're not forward thinking in that by de-risking things for themselves, there's a potential that the game ceases to get the level of support that it needs to succeed, which then obviously impacts sales, and it's a vicious cycle at that point. But there are a lot of big publishers in the industry, including some in this country, that you probably figure out who we're talking about, that are pretty adamant that full recoups what's needed. You can negotiate with these people and try to get some advance payments post that initial launch point, but I think it's probably part of an antiquated approach that a lot of publishers have. But as I said, I get the de-risking of their investment part, but if it jeopardizes the team or just stresses the developer out. Like in sports or in business, if you have pressure on your star player, they're not going to perform to their best. And I think early on in launch, especially if it's not early access, whatever we're calling it now, where you do have that iterative development process and you need to have your team committed. If it's jeopardizing that, then I don't think it's in anyone's best interest. So, an in-between approach is to try to get that advance being paid, even after release, or also just to get a small royalty. 10% might not cover everything, but maybe it'll cover something. Do 90-10 until full recoup, and then 50-50 or whatever the numbers are. So there's ways can be negotiated, and hopefully the publisher's receptive to it. But get multiple publisher deals too, right? And then you can pit them against one another. Look, I really want to sign with you. I love the games you publish, but I've got so-and-so, another publisher out there in the wings willing to give me something slightly better. Maybe you won't get it, but at least you can come from a better position of negotiation, saying that there's somebody else on the table.
I mean, just send those publishers in the negotiation. Send the publishers to my blog and tell them, like, listen, Chris says to update your game forever. So stop with this business where it's like disadvantage yourself by not updating and patching. It just boggles my mind. Okay, so you've done studies where you looked at, I think it was a couple dozen, 50 or so publishing agreements. What's kind of the average that's kind of going out the door right now for an advance that they give to an indie publisher or an indie developer, I should say?
Yeah, we looked at probably 50 plus agreements, 60 plus agreements, and we tried to pull out kind of 10 standard data points that were consistent between all of them. And obviously some of those were the advance and the royalties and things like that. So just looking at my phone here, pulling the data, the average we saw, if we included 0 advance deals, because those do exist, and I'll do an aside on that, but it was around 318,000 US. All these numbers are in USD. But if we just focus on advance only deals, is about 460,000. The lowest in our data set's around 100. Highest is it's in excess of 2 million. And so I think probably on average, you're looking at about 500,000. On the 0 advance point, which ties into this discussion about what the rev share should be. If the 0 advance deals are where you've already done most of the development, so you don't need much money at all coming in, and so the publisher's serving purely a publishing role, which you would think, well, I could self-publish, but there are a lot of publishers that'll say, look, 0 advance, but we'll do the marketing in-house. We have a really good network, and we can handle the publishing in certain countries, Asian markets, things like that you couldn't do yourselves. You can do some porting, and maybe porting's not recoupable either as a cost. So you do see those, and then the correlation there in the data set is, as you'd expect, where if you have a 0 advance deal, then expect a much higher revenue share. I've seen as high as 90-10. The publisher regretted that deal. Definitely regretted that deal.
So wait, the developer got 90% of all money coming in. Wow.
This publisher was a big company that wanted to get into the space, but I think they learned their lesson on that deal. And then I think more so you see 70 or so. But you can actually go to videogamepublishing.com, and we have this data, and you can actually, putting aside the legalese, submit your own terms as well on an anonymized basis, so we can build out the anonymized data set.
Yeah, and I'll put a link to that down below after when I upload this video. So yeah, definitely check that out. This is good information because I collect marketing information and anonymize it. So you're like that, doing that on the legal side, which is fantastic. Great resource. Now,
yeah, I was going to say it solves that informational disparity problem too, right? You as devs just don't know much about these deals because it's the first time you've done them, versus publishers done it a million times. This is their standard document. So if you're negotiating by just calling your friends and saying, hey, what deal did you get? That doesn't help you really be informed in that. In the startup sector, startups actually do deal reports, like law firms do quarterly deal reports and keep everyone informed. So the guiding principle there was everyone should have the same information base going into the negotiation, and to kind of level that playing field through the videogamepublishing.com.
Great. Now you also mentioned, that recoup, there are expenses that they, kind of hold against you a little bit that you have to basically pay off. Now there's internal expenses that need to be recouped and external expenses need to be recouped. Can you kind of describe kind of how that shows up in the negotiation and maybe in the contract?
Yeah, there's going to be a net revenue number that's calculated, and they're going to say, we're going to take gross revenue, which is the amount of money we receive from sale of the game, and sale's usually the drafting error. It should be commercial exploitation because you often don't sell the game anymore. You could have like a streaming service, Netflix and everyone's previously Stadia, or it could just be an advance. That's not a sale of the game. Like if Epic gives you an advance to be exclusive with them. So always look at commercial exploitation versus sale. But internal would be publishers' own marketing work. Like they have their own marketing team and they're a bigger company. Why should you be covering their actual internal overhead? If they have their own internal porting, as some of the larger publishers do, why is that being a cost that's recouped by the publisher? Part of the reason for signing for these publishers is because of their sophisticated teams. But if you're paying for it like any other third-party company, then what's the value in the publisher? You can go with anybody for these services if you're ultimately paying for them. So those internal costs, my view is they shouldn't be recouped. And a lot of times they're not, but you need to look at that net revenue calculation. External costs is anything that's obviously done by a third party in connection with the game's publishing. So third party marketing can be recouped for sure if the publisher doesn't have that skill set, but you should at the same time wonder why they don't. But if assuming they do, they don't, then that would be a recoupable cost, but you still want to cap a lot of these recoupable costs. So if they're going to have to engage a third-party marketing company or a third-party porting company, then those can be recoupable. I'll concede, but let's try to cap those expenses so you actually understand how much money you're going to have to generate from sale of the game before you start seeing any royalty being paid or that higher royalty rate. If you just have porting costs, marketing costs, and those are theoretically unknown numbers, they could engage the most expensive, useless porting company in the world that delays, and charges a fortune. And you're not going to get any money anytime soon under 100% recoup structure.
Gotcha. Yeah. So I sometimes get hired by publishers to help consult, give them some marketing tips and stuff. Am I internal or external?
I think you'd be external. But I think it just goes to, you wouldn't be named specifically, but maybe a publisher or developer wants to name you specifically and say that they're willing to pay for some or all of your cost or not. But I think
you hear that, Indies? Put me in.
Write them in. But I think it's really good for anybody, whether you're a developer or publisher, to have full insight into the metrics that go into how your business generates revenue. And these figures that are subtracted from net revenue ultimately determine you as the studio's revenue. And if you don't have insight into what those costs are going to be, especially that fixed number that I proposed, then it's really hard to operate a business and even to figure out payroll and growth of the studio if you don't know what these numbers are at that early stage when the revenue trickles smaller. Later on, it doesn't really matter. If you've recouped all of those, you're probably not going to have huge expenses after that date.
Gotcha. So in that contract, will you put in some sort of statement like not to be, no internal cost in this, only these external costs, and they are delineated like, ad spend $50,000 or whatever, that kind of thing? Is that kind of what it looks like?
Yeah, that's how it looks. And usually I'll only talk about external costs. I'll write elsewhere in the agreement, and it's often already there that the publisher is going to do X, Y, and Z for the developer. And if it says the publisher is going to do X, Y, and Z, and it's not enumerated in the list of subtractable expenses in the net revenue calculation, then it's implied. And so I'd rather not write it in there and create a discussion around it. I'd rather rely on the agreement, not expressly saying it's a subtractable expense to arrive at net revenue.
Wow. That's what, when you start mentioning that, they're like, wait a minute, this kid's got a lawyer.
There's the hack.
Good, but bring it. Okay. And then in there, sometimes a marketing clause. Speaking of marketing consultants and stuff, what's a marketing clause?
The marketing clause is usually going to set out what the publisher's obligations are to market the game. We'd always recommend where the publisher's talking about an amount of money that they're going to spend to have that written into the agreement. I mentioned that a bit earlier in this chat. The publisher's often going to be reluctant to write in that amount that they verbally promised multiple times into the agreement. So you might want to frame it as a minimum. So while they're saying they're going to spend $100,000, then you could write a minimum of $50,000 on marketing. But you're also going to want approval of a marketing plan that's probably jointly agreed to between the developer and the publisher, because you want to make sure that the game is being published in a way that accurately reflects your title, but also even your product plans. So if the marketing tone's wrong, or even kind of where they're proposing marketing the title, doesn't fit with the nature of the game, then, you need to know that up front. We definitely have heard of games where the game's marketed completely wrong, film noir, and it's got like a comedy tone in the trailer, and that could tank the game. So having a jointly agreed to marketing plan, and hopefully that marketing plan will have some specificity, would be great. Ideally, you'd love approval rights for all of these kind of key events, trailer, things like that. Most publishers do not like relinquishing control over these kind of things because they know best. I'm quoting them. But so you may not achieve that, but at least if you can put in some sort of jointly agreed to marketing plan, you can fight out the details of that marketing plan at a later date. As you can kind of tell, a lot of these things are kind of concessions trying to achieve a middle ground for both parties, and you're kind of on the back foot the whole time because you need publishers' money. So you're going to have to accept at times, and that's part of our role too, is to kind of figure out, where can there be a bit of permitted ambiguity versus not, and just make sure the client's informed that at that point they may have to push a bit, because often our clients just want to get that money in the door, and they're willing to delay a later fight on what that marketing plan actually says, to that later date.
I mean, and to be honest, like, this is kind of where it's not adversarial all the time. Like, I'm a marketing consultant. Sometimes I come in and that marketing plan is just, it needs to either change or adjust. And sometimes, and I'll be honest, some indies, it's their baby and they can't see it, they can't see that objectively. And we're like, hey, this is really how you should market this game. And they're like, but no, or it's flip-flops. I've worked with indies that flip-flop their marketing, how they want to message their game, depending on who their last friend they talk to. So, it's not always bad if a publisher says, hey, we know best. Like, I just want I want to let indies know that it's not always bad because, I know it's your baby, but somebody's got to sometimes say some things like, hey, this is the way it should be.
Totally. Agreed.
Okay. So, DLC porting costs, that comes up at this time. When you're negotiating these contracts, even though they seem like post-release way off in the future, what kind of things look bad or kind of weird that you always pay attention to?
If there is a DLC obligation, I want to know if it's actually a hard obligation on the developer. I want to know how it's getting paid for. Going back to the earlier point about the royalties and things like that, right? If you have a hard obligation to make DLC as the developer and you don't have any money coming in to fund that, I don't know how that's viable. If the expectation is for you to fund it yourself, then why is it the same royalty as the main game itself? Ideally, there's going to be extra advance payments to cover that DLC. So that's certainly something you're going to be looking at to make sure that there's actual financial viability for the studio over that DLC development period. We also see issues where there's a question of who controls the creation of DLC. In my mind, the DLC creation should be something at a minimum mutually agreed to between the developer and the publisher. But sometimes we do see clauses that say that the publisher can request its creation. And if the developer doesn't make it, then the publisher can make it. And a lot of these things go to creative control decisions. Some DLC may not match what the developer expects for their title. So usually I would like to see that if the developer wants to make the DLC, X, Y, and Z, or if it's a hard obligation on developer, then have the money flowing through, at that stage to make sure that it's being paid for in some way. Gotcha.
And kind of speaking of like DLC and how the publisher might have different ideas for it, this kind of goes back to the original, one of the clauses, which is the licensing. You're giving them the ability to license your game, but you always say remove these overly broad licensing terms. Can you kind of go into like what you typically sign over when you sign these agreements?
Yeah, so usually when you sign these agreements, you're giving the publisher a license to publish the game. Seems simple enough, but a lot of those scopes to the license are unnecessarily broad. So it might give the publisher an exclusive license to not only the game, but to characters, to storylines, to the game universe. And a lot of those terms that are overly broad are really problematic because effectively they would prohibit you to develop sequels without the publisher's consent. Because if you're trying to make a sequel, you're going to use the same universe. You might use the same characters, or even the same audio, right? You might, if you have a great theme song to your game, and that's exclusively licensed to the publisher for the term of that original publishing agreement, then you can't use it on game two, even if publisher waives their sequel right. So you need to be really cognizant of that. And I don't think it's a nefarious intention on the publisher's part. I think it's just really sloppy legal drafting that doesn't think about what the actual import is of these terms if you extrapolate out beyond the original deal. So usually I'm looking for just the game itself, and there's legal nuance to it, that they can get a right to exclusively. But it should be non-exclusive for a lot of the other things. Not exclusive for audio, or even more importantly, it talks about developer trademarks. Well, if developer trademarks includes the developer's own studio name or even the game name, then they could never use the game name for the next game, for the sequel, and they could never even use their own studio name again. It even goes so far as to say that it's an exclusive license to market, which is license isn't the right term for that, but that's what they call it. But then how can the developer do any of their own marketing? Usually they run their own Discord, or they even have their own website, or they go to GDC and talk about their game. And if they do that, isn't that marketing? And that's an exclusive right of the publisher, so they can't do that. Or making swag. If it says the publisher has an exclusive right to make merchandise, can you make team merchandise for your own team members to wear? Theoretically, you can't.
Wow.
So these exclusive licenses, which should be limited to intellectual property to the game, often extend beyond the game to merch and other things. You just need to be really careful understanding that exclusive means that even you as developer can't use it. And on the game code side too, right? If publisher has an exclusive license to game code, then you theoretically can't use your own code to even fulfill your obligations. They would never call you on it, but it's just not reflecting the nuance of what exclusive versus non-exclusive means.
So do you have to fix this, to do this right, do you have to flip it and say, legally, you just have the legal right, the license to the game itself, and then you have to list all these exclusions: no marketing, no code, no name, no company name, no songs? How do you make it favorable to an individual? What does it kind of look like?
It depends how it's originally written, because you need to play within that framework. But usually I'm limiting the exclusive scope, and I'm saying that for these other things, it's a non-exclusive license. Or I might say, if the publisher won't allow that, I'll say, for some, for example, maybe they won't let them have that on game code. They want exclusive on game code. That'll be fine. But I'll say, notwithstanding that, the developer gets to use game code, gets a license back almost, or exception to use it to fulfill their contractual obligations. So there's different ways you can achieve that goal. I don't think I usually see a full list of non-exclusive X, Y, Z, but you do need to think about that, and that usually goes to the definition of what the game is, because game might be really broad, and so that's what it needs to be focused on.
Yeah, that's what seems so wiggly, is the game. If you just say the game, what is the game really? Where does it stop? So, wow.
Yeah, exactly.
Okay, why don't we? I'm going to switch over to questions, and I'm going to start looking for some. But while I'm looking through some of these questions, why don't you just give one final, plug of where people can find you? What's the best way to kind of contact you, that sort of thing? So, folks, you populate the questions in the QA tab, and go ahead and give the pitch.
Sure. You can get a hold of me, Voyer Law, VOYERLAW.com. And you'll find my email there. Send me an email. Glad to have a free meeting and just talk about what your studio is up to, and where I can add value on the legal side.
Great. Okay, let's go to the top here with Hunter. Any experience with funding for VR games? Seems like typical publishers are not interested in VR. Yeah,
I haven't seen a huge number of VR publishing deals lately. When VR first was bigger, like the PSVR era, we saw a lot more of them. I don't think it has anything to do with the legal side of things, and VR publishing deals are largely the same, in my experience, as regular publishing deals. You might see some nuance though, around arcades in Asia, because you have a lot of those. At least I don't know if they still exist, but before the pandemic, you had a lot in China of these VR arcades, and you'd see kind of unique clauses around how you might get a royalty for that, which is a unique aspect of VR. But I think it probably just goes to the publishers realizing, and Facebook itself, Meta, realizing that the VR market hasn't taken off as quickly as other companies expected. And so I think we're going into a recession. Sorry to say that bad word. I think they're probably thinking that that the headset purchase rate isn't that high. So you have a smaller market. That'll be fixed maybe with the new PSVR. But these are expensive things to buy. And if people are cutting back on costs, then that limits potentially the growth of that market where we're reliant on several $100 headset units, even for something that's fairly good.
Gotcha. Okay, here's one from Nicholas. Our studio already has a lawyer on retainer since we use them for each company we have, for a tech company that we have. They have experience with negotiating contracts internationally, but no game dev legal experience. We're about to start pitching publishers. In our specific case, would you recommend to contact a specialized lawyer such as yourself? Would it be feasible for the specialized lawyer to work together with our non-game dev lawyer?
Yeah, I mean, personally for me, it's all about collaboration. So especially if you're in a foreign country, right? If you're in Brazil or something, I'm not going to be your general corporate counsel for that. But for just focusing on one area of expertise, we definitely collaborate with other lawyers all the time. So I think any lawyer you work with would be glad just to provide that limited focus on the publishing agreement and leave the rest to the current relationship. I think if you were to rely on a general corporate lawyer to do the work, I don't think you're going to get the same value, because some of it is the stuff I've talked about, the nuance that you only get from seeing a lot of agreements and kind of developing that expertise. But on the business term side too, right? If you want to ask your lawyer, is this term common? Well, unless you've seen 60 plus publishing agreements, how can you really opine on that if it's their second publishing agreement they've ever seen, or maybe even their first? The same thing for us though. I'm a lawyer, but I'll never do a real estate deal because I don't know what's standard, and I can maybe figure things out and teach myself, but I know I'm not going to add the same kind of value as someone that really has that domain expertise. And so I think we can be brought on, or any video game lawyer can be brought on for that subject matter, that domain expertise, and then leave your regular lawyer there to do the day-to-day.
Great. What do publishers typically take their cut from? Is it gross or net revenue?
Almost always net. I've seen a couple gross. They might give it weird names, but if it's how you normally would define gross and net, it's almost always from net.
Great. And what are maybe, like, let's say, top 2 or 3 red flags? If you see this come across your desk in a contract, what are you like, run, get away from that one? What are they?
Oof, 2 or 3. I would say intellectual property ownership is probably the first. If it says that the publisher owns the game, the publisher won't move away from that position, and it isn't like a work for hire kind of thing, I would seriously reconsider that transaction, especially where you've been working on the game for a long time before. Like, there's no reason why the publisher should own the game. To me, that's the biggest one. I'd also look at termination clauses. I'm also very concerned about them. So how can the publisher cancel the agreement? But how does that connect to one IP ownership? Because sometimes they'll say, well, if you breach, and breach is kind of in the publisher's discretion, we can take ownership of the game. That could be super problematic, where you don't really have a say to debate what is a breach. But it could also prompt an obligation to make repayments. So I would say look at that termination period too. What's the third biggest issue? There's a bunch of other more minor ones. I think to make sure that you have an audit right, if that's not added in as it's just industry standard, I feel like there's something suspect with the publisher. There may not be, obviously, but an audit right is the right of you as the developer to double check the numbers behind the royalty that's paid to you, so you can make sure that actually you're getting the right amount. Because to be honest, they could just be fast and loose with the accounting, not because they're bad people, but because they have a bunch of games and they're not the most accurate. And if they're not willing to provide that right, as is in almost every publishing agreement based on the data sets we have, then I'd be really concerned about that, because anyone working in this industry should be used to what the standard asks are, standard clauses are in any agreement.
Great. Okay, next one comes from Zach. His situation is that they don't need funding. The game's almost done. Should I make it clear and abundant that I don't need to take an advance? Does that refusing that give better terms and better negotiating power?
It might not. As I said, there are the 90-10 publishers out there. But I think it's great because if you look at it from a business perspective, it materially de-risks things for the publisher. The publisher's high advance, in my opinion, high revenue share, is predicated on there being risk in the deal. Where there isn't risk in the deal because the game's nearly done, then I think to a publisher that's an easier thing to put out there. I think the pain point is going to be how much they're willing to give on the revenue share, to reflect that. And some publishers are very firm that this is our standard deal, and they don't move away from that much. So you may have a problem just shopping around for a publisher that's more malleable in their terms to reflect that. Yeah, I think the other benefit though too is some publishers can then allocate that advance. If they say, look, we always want to provide an advance, we always need this kind of rev share. If you can get to the top end of their rev share, then maybe you get a higher advance, but it's focused on a very particular thing, like spending a ton of money on marketing because you actually have a cost of acquisition per user. Maybe you're a mobile game, and so that matters to you. So there might be a way that having advance can still be to your benefit if you do have those higher marketing expected costs.
And I think I saw in your data that you collect from all those devs that they did get individual indies got better, a higher percentage when they didn't have that initial investment. Is that correct?
Yeah, let me pull up my data here and see what the actual number is. Because I think it's about 70%, give or take, that you see as the rev share paid to the developer. So I think it's a positive. But I've heard from clients where they are shopping around a game that's near done, that they run into a bunch of publishers that are fairly consistent that they need the X, Y, and Z deal terms on most of their deals because they just need that kind of return on capital. So for them, it took a bit longer to find the right fit with a publisher because a lot of them, once they spoke to, just had certain needs on the deal term side of things.
Great. Here's a question from David. Most contracts ask me to warrant that I haven't infringed patents. Since you can unwittingly infringe, I can't agree. Any suggestions regarding these clauses?
I agree that you can't agree. You could put the word knowingly in front. So you don't knowingly, you rep and warrant that you are not knowingly infringing. And then you can get into what knowledge means. Typical lawyer answer would be your actual knowledge, but that which you should have known after a reasonable investigation. It's kind of sophisticated to define knowledge, but that would be how you would normally define it outside of the video game sector. Otherwise, though, a lot of our clients just accept the risk. They take the position that there probably aren't many patents in the video game space. Software patents, really difficult to get in the US. A lot of them are being invalidated as well. So, what's the likelihood of that happening? You don't hear about that happening much at all. You do hear about infringements for trademarks, design patents. So if we're talking about military hardware, there are design patent issues. I think that's probably the most likely patent-y type issue. But with the reps and warranties, I find a lot of publishers are unwilling to go huge lengths there because each time you narrow the scope of a rep, you're increasing risk to the publisher. And already they're viewing this as a risky transaction and that they don't know if the game's going to succeed in the first place, especially where there's a long tail to development in a high advance. So it may be a necessary thing to accept in order to get the deal done. But that's not to say that it's something you should do without much thought. There is some weight to that, but I think it's on a per developer basis what risk they're comfortable with.
Great. Mark asks, what published licensing term length do you recommend, aiming from the developer perspective?
The average in our data set is about 7 years. I'd see between up to 10. So I'd cap it at 10 myself. I think, though, you need to be cognizant of how that connects to other clauses. And I would like those other clauses to have a shorter duration than 10 years. So, for example, sequel rights. I don't think you should have sequel rights for 10 years. That seems a crazy long period of time. The publisher could have been bought and sold 3 times over that 10-year period. So I'd like some of those clauses, especially sequel, to be 5 years or something rather than 10. So I'd always look out for that. It shouldn't be perpetual, as in forever. You do see perpetual, but you suddenly have a sequels clause that exists in perpetuity. That's really crazy. You always have to go back to the publisher. And just on those points, too, on the sequels clause, just make sure it's not on the same terms as the head agreement. You don't want a sequels clause that says publisher gets the publisher sequel on the same terms as this agreement. Because this game could be wildly successful and you suddenly have a bunch of other publishers knocking at your door. Why would you agree to 50-50? Why would you force yourself to agree to 50-50 in that original agreement when you can get 70-30 from somebody else?
So is that something where you just say to be negotiated later for any possible sequels or something, or what is it?
Yeah, like negotiated in good faith. Usually it says that the parties will negotiate in good faith for a period of, let's say, 60 days. If they don't reach an agreement, then developer can go off and seek its own publisher for that sequel. There may be a right back, though, where if developer gets a deal it wants to sign for that sequel, it might have an obligation to go back to the first publisher and say, do you want to publish on the same terms as this other deal? So you may not be able to completely escape the grasp of your previous publisher, but at least it'll be on the best terms, that you were able to obtain on the market.
Yeah. Speaking of kind of playing publishers off against each other, somebody had a question. I couldn't find it again, but one of the questions was basically like, can you use the terms that you see in one contract and bring it over to another publisher and say, hey, we're getting this over here. Is that okay? Is that normal?
There's going to be a confidentiality clause that says you can't talk about this. I think practically, it's being recorded, but practically people take the deal terms, anonymized and say, I have another publisher that's offering me 60-40 instead of 50-50. So while admittedly that's probably breaching a confidentiality obligation, I know you're not naming anyone, but technically it probably is. But it happens all the time in the industry, and I think it's the only way to get business done. So disclaimer on that, but it happens a lot. Just don't name anybody, right? Yeah, proceed with caution. Don't name anyone. But it's like buying a car, right? You want to get the lowest price possible, or hear the highest advance and perhaps the best rev share in your favor.
Great. What happens if midway through development we realize that we need more money or more time? Is it worth to include that in the contract with the publisher?
Sometimes it's there where we see some deals, actually, I think I did one last week, where actually it permits a certain amount of overspend. And then it ties into the rev share, though. There's like a penalty for that. So sometimes it's baked in. Other times it's not, though. And you have a hard milestone schedule that needs to be hit. Deliver alpha by this, beta by that, gold master, to use a bit of the data term, by this date. So if you run out of money and you go over, often it could be a breach of the agreement. So it's on you, and it kind of makes sense, to be honest, right? A lot of money is being put behind you to make a game. There's an expectation that, assuming the feature set doesn't change, then and that should be controlled by you, not the publisher. Then then it's on you to have proper project management. If you think there's going to be issues because of the scope of the game or technical changes in the industry, maybe in VR or AR, then if you can build a buffer in, that would be good. We don't always see that in agreements, though, and so it's not a guarantee you could achieve that, but that's what I would suggest. And going to the creative control point, like we do have a client that we've seen where the publisher has asked for additional features to the game, and they've kind of exerted their own control over the scope of the game, and it's led to things being pushed out. So it's important to have those milestones really baked in, and if there's any publisher requests, like you deliver milestone 1, the publisher comes back and say, that's great, but hey, wouldn't it be awesome if you had these other features? And if you concede to that, suddenly you're pushing out milestone 2, but there's no obligation for the publisher to agree to change milestone 2. So you really need to have that firm foot and to write, well, first, clarity. This is exactly what milestone 1 is. And when that feedback comes in on milestone 1, to push back and say, look, that's a new feature. It's on milestone 1. We're not going to change anything unless you give us more money or you agree to push back to milestone 2, whatever it is.
Great. Now, I guess this depends on the country, but what would you expect to pay for a decent lawyer? We're not talking we're not talking Better Call Saul here. We're talking a decent video game lawyer. And exclude yourself from this. We're not revealing anything here, but let's do this. What are some ballparks to say whether I'm getting Better Call Saul versus a quality video game lawyer?
I think the review of let's just talk about publishing agreements then. Like, to review a publishing agreement, the cost depends upon how crappy the agreement is versus good. And by that, I mean, you'd be surprised at the very poor quality of a lot of these agreements. And I don't think they were originally that way. I think it's the marketing department hacks up agreements over time. And at one point, a lawyer wrote it. But they have been modified so much that, I don't like to overly draft if I don't have to, because the more changes you make, the more publisher has to review and the more pushback there's going to be. So we try to keep our changes to a minimum, but you'd be surprised by how many errors there can be in these agreements, as we've kind of talked about this whole chat. So that's what drives cost a lot of the time. I'd say, a minimum $1,000 if it's really basic, but they can go from 1,000 to 10 grand. If it's a $2 million deal, you're going to be spending 10 grand for sure on that. So usually what we do is we like to get a copy of the agreement from the client, and we can then say, based on what we're seeing here, we think it's going to take X number of hours. But usually that's just for the initial review, right? We're going to put together a set of amendments that are going to be reasonable. We're not looking to change governing law just for the sake of it, because publishers usually aren't going to agree to that. So they're practical, prudent amendments. And then it's a question of how much back and forth there is with the publisher, because that's also what's going to drive cost.
Gotcha. Just a quick kind of general question. I mean, you do agreements with publishers and stuff, but do you also do, maybe internal contracts for like, I'm hiring a contractor to make this character for me and stuff like that. So I need a contract for this person here to work for me for a little bit. Is that something you do too, or is it all publisher facing?
No, I mean, my talks, a lot of my public exposure has been around publishing agreements, because I have a weird fetish interest in publishing agreements. I think it's because of how poorly they're drafted, so it's kind of fun to play with them. But we're a full service firm that focuses on working just with technology clients. So a large part of our client base are video game studios, and we handle things from forming your studio to employment to trademarks. Maybe we can patent something. Whatever it is in the life cycle of a game studio, we can handle, because we realize that if they don't already have their own corporate lawyer, that they're not going to go out and get like 3 different lawyers. They're not going to have like an employment lawyer to draft an employment agreement, a trademark lawyer, and a video game lawyer to do a publishing agreement. So just too much time and money. So we try to create cost efficiencies by consolidating it all. And for us, we can do the US and the Canadian side.
Great. And does that, so then do you have recommendations? I mean, not literally the recommendations, but if somebody comes to you and they say, hey, I'm working out of Germany or something, do you have contacts that you can forward people or that sort of thing?
We definitely can. So if it's not a publishing agreement thing, then it's corporate law in Germany, then we have connections and all of that. If it's intellectual property, usually we can do that internally. And for a lot of publishing agreements, to be honest, they might be Swedish governing law and things like that. And so for us, we can add value just focusing on our knowledge of publishing agreements, and then we can loop in a Swedish lawyer, for example, to look at an IP clause. We did that recently, and we said, hey, this in North America, this would not fly. In Sweden, how would this work? And they can be very cost limited and focus on that, because in some countries, there may not be video game lawyers as common as there are in let's say in the US or in Canada. And so, there's nothing wrong, in my opinion, with bringing in that subject matter expert to focus just on the publishing agreement aspect, and then having a local lawyer as needed to give it a second look over to make sure there isn't some nuance to that particular country's laws that needs to be addressed as well.
Gotcha. And what's the best way, I mean, other than talking to you, to find other lawyers that are specialized in the game space, because it is a very small and very specific, type of, of contract and everything. Is there like a guild of, video game lawyers or something? How do we find you or your other compatriots?
There is a super secret video game bar association that's invite only. So there is actually a secret guild. I didn't create it, don't worry. So I don't.
You're not spoiling the secret.
No, I think I just did. But I don't think they list who the lawyers are. I think I'd say Google's your friend here, but I think that's a starting point. I think you'd probably be looking for technology lawyers, and then you often will find video game lawyers, because kind of as an offshoot of that, maybe media entertainment lawyers too, but they're all separate. Like startup lawyers are not video game lawyers. Film and TV lawyers are not startup lawyers or video game lawyers. So if it was me, I probably would start that search query, or to look at who did talks at all the big conferences, because every year I think you do see some video game talks at a lot of these big video game conferences, and there could be some names there in your particular country, whether it's the UK, Canada, the US, that you can reach out to.
Great. Yeah, I always see that because we get the ratings back and we see who is the highest rated talks. It's always the lawyer talks in these conferences. So it's it's a much needed service. All right. Yeah, I think that's it. So thank you so much. Why don't you give one final pitch where people can find you? What's the best way if they need some services? What's the best way to get in contact with you?
VoyerLaw.com, VOY, V's in Vancouver, OYERLAW.com. Or you can go to videogamepublishing.com if you just want to look at data sets on the publishing side of things.
All right. Well, thank you so much. Thanks a lot. And I just really appreciate you coming out and spilling the beans on how your guild works. It's so important. So
Thanks for having me.
Thanks so much.
Bye.
Bye.